Justices, our courts have a very proud tradition of ensuring equality before the law, of ensuring that everyone is subject to the law regardless of their status. That if you are a former president or an Olympic athlete, the law will be used equally. And the Rule of Law Project's concern is that the Court of Quo's judgment doesn't do that. That the rules that are applied to Mr. Malema differ in many ways from the rules that were applied in other hate speech cases. There are really 4 issues to address. The first is that the Court of Quo seems to create a special category of protection for speech uttered by political role players. And this elevates politicians over ordinary citizens. It says that their speech is more valuable, more protected, and that is not something that we find in our law. We actually find the reverse. In Kulani, as has been discussed, the status of the speaker matters enormously. That the Constitutional Court found that because Mr. Kulani had a public role, he was a writer, that must be held against him. Secondly, equality before the law requires that the rules of evidence are applied equally in all of these hate speech cases. Now, my learned friend, Mr. Ngatobi, referenced the Kulani High Court case, and our evidence was led in that case, and all of the evidence was allowed. It provided the valuable context about homophobia and violence against the gay community, and that was pivotal in determining that Mr. Kulani's speech constituted hate speech, as much as it was stressed that there was no causal link between the article that he wrote and any of the harm suffered by the community. It's never been a requirement in our law that there has to be a causal link, and Kulani in the Constitutional Court establishes this. And of course, one of the difficulties with the Court of Quo's judgment is to exclude all of the evidence on the grounds that it couldn't prove a causal link between the song and the harm that was suffered, but it was never a requirement. Third, the Court of Quo held that the appellant failed to show that the song Kill the Boer targeted people on any of the listed grounds like race or ethnicity. Now, it seems astonishing to think that no one knows what Boer means, that when the Anglo-Boer War is taught, no one thinks it's between the British and farmers. They know that it refers to the Afrikaners, that Mr. Roots testifies that the term Boer has a dual meaning, one that it can refer to farmers and the others that it can refer to Afrikaners. And Afrikaners must be given the same respect as all other citizens in this country. That the Constitutional Court, when dealing with the term Zionist in the Masuku case, could say, well, it's clear that the term refers to Jews, that you don't have to say Jew, it can be implied by using the term Zionist. And so when there's a double standard of saying, well, Afrikaners are a group unworthy of protection, like gay people and Jews, that's a very dangerous precedent to set. And fourth, the Court of Quo's judgment undermines the founding value of non-racialism. It creates different rules for different races, and this is a topic that has come up in some discussion today, the idea that maybe some people should have different statuses depending on the color of their skin. That flies in the face of the foundational value of non-racialism entrenched in Section 1 of our Constitution. In Section 9, the idea that we're all equal before the law, and specifically in the Kamalo judgment, where Justice Sutherland addresses that issue head-on and goes into some detail why we don't have different rules for different races. I'm now going to start with the speech by politicians and why it's so dangerous. Mr. Ngatobi wants to belittle the role of Mr. Malema, to say, well, he's just sort of speaking at birthday parties. This is the leader of the third biggest political party in the country, who can amass a group of members of parliament to storm the stage that the president stands on, who can have a birthday rally that is televised around the world with 90,000 people at it. This is someone who has way more stature than anyone else in any of the hate speech cases. This is someone who has a much bigger reach than someone like John Kulani or Mogani Masuku. That status matters. And it is warned about by the United Nations Committee on the Elimination of Racial Discrimination. They produced a report about South Africa where they said there is a concern about the rise of hate crimes and hate speech in South Africa, including physical attacks against certain ethnic groups and non-citizens, discriminatory statements by state officials and politicians, and the increase in the use of the media and the internet to propagate racist hate speech. And the committee further recommends that the state ensure all incidents of hate crimes and hate speech are investigated and prosecuted, and the perpetrators are punished regardless of their official status, instead of saying that they're given a special extra freedom to propagate hatred. The idea is they must be held to account. And this is echoed by the Constitutional Court in the matter of economic freedom fighters versus the Minister of Justice, where Mr. Malema had been charged with breaching the Rights Assemblies Act for calling on people to take land. And the Chief Justice there said, "No constitutional right is absolute or ranks higher than all others in this country. In our enjoyment of these rights, a greater sense of responsibility is demanded, particularly of those who are thought leaders, whose utterances could be acted upon without much reflection by reason of the esteem in which they are held and the influence they command. After all, leaders from all walks of life ought to bear heavier responsibilities than all others to help preserve our Ubuntu, justice, and equality-based heritage and actualize our shared aspirations." So in the case where Mr. Malema is specifically mentioned as someone who carries enormous political power, the Chief Justice says you must add additional burdens to these people. Now, some of Mr. Malema's testimony gives some credence to this. He says that he believes he will be the president of South Africa. He describes the EFF as a very radical, very militant party. He says, "I never said I'm somewhat moderate. I'm very radical and very militant, and I make no apology about that." And when asked whether he would embrace violence as a process to decolonize South Africa, he responded, "Colonization is violent. It is like racism, and the only way to deal with violence, you must be violent. Therefore, there's nothing wrong in engaging in a revolution, and one to be suggesting that you cannot be engaged in violence. Revolution itself is violence." When he was asked whether he would be happy to endorse the use of violence for his revolutionary aims, he responded, "My Lord, when the time comes and the conditions on the ground necessitate that arms must be taken, we will do so without hesitation." He says, "I am not scared of killing. A revolutionary is a walking, killing machine, not scared of death. If that need arises, I will kill. I will do so with no hesitancy, especially in defense of my people. We are very angry and ready to kill." Now the suggestion by my learned friend that this is all metaphor, that this is about the destruction of the apartheid system, is complete and utter nonsense. Mr. Malema testified that he is happy to endorse killing. When asked, "Will you pledge never to call for the killing of white people, not a system, for the killing of white people?" he refused. It is very clear from the speech itself, "Kill the Boer, kill the farmer," from the testimony of Mr. Malema himself, it is targeted at people on the basis of their race. And he has no problem with killing. He says it very openly. Well, the point is to say that there must not be a double standard, that you must take into account the status of the speaker, that you must take into account the testimony. So the amicus cares about the rule of law being applied equally, that there cannot be a special protection for someone on the basis of them being.
That point, I would think, rather than highlighting aspects of Mr. Malema's evidence which are not before us as hate speech. It's the song being sung on particular occasions that are being used as hate speech, not what Mr. Malema said elsewhere.
Well, the point of it is that you must ensure that people are held to account in terms of the law. The law makes it clear that the status of the speaker matters.
I understand that. Stick to
Yes.
that line, I would think.
Now, with regards to the expert evidence that was dismissed, my learned friends for the EFF state in their heads of argument that the structure of the original trial mirrors the structure of the Kolani trial. Now, one of the bases for Mr. Rutter's evidence being disqualified was on the basis that he is a member of AfriForum. However, in the Equality Court trial of Mr. Kolani, the court admitted the evidence of Mr. Gregiaru, who worked for the Human Rights Commission, its own employee. Now, another reason for disqualifying Mr. Rutter's evidence was that he had a personal interest in the matter because in his book he says, "This is personal for me." Now, in Kolani, Professor Nell testified about the deleterious effects of homophobic speech, and he testified extensively about his own ill treatment and discrimination meted out to him by virtue of his gay and sexual orientation status, and his evidence was accepted. In other words, the fact that he had a personal stake in it because he himself was gay and had been subject to discrimination on the basis that he was gay was not a reason to exclude it. Mr. Human's evidence was excluded on the basis that the physical and psychological effects that the farm attacks have on their victims constituted hearsay evidence. However, in the Kolani trial, the court admitted the evidence of Mrs. Mokoena of Power about a series of lesbian women that had been correctively raped. The court did not dismiss the evidence as hearsay, despite the victims not being called to corroborate their testimony. The court disregarded the appellant's expert evidence of Mr. Krause about singing of the song Bizani Fire Brigade on the basis that he had not proved there was a causal link between the singing of the song and farms being settled out in the region. However, the Constitutional Court made it clear that considering the phrase to incite harm, it is imperative to point out at the outset there is no requirement of an established causal link between the expression and actual harm committed. The court disregarded the appellant's lay witnesses who testified about their personal attacks that they had suffered on the basis that they could not prove they were attacked because the singing of the song killed the Boer. However, in the Kolani trial, evidence was admitted by MN, who testified about her personal abuse that she suffered because of her sexual orientation. The court says, like Mokoena, MN conceded readily that the incidents perpetrated on her cannot be directly linked to the applicant's offending statements. However, she added that the offending statements were exacerbating the current situation and people like her are being harassed. In other words, they provided important context. The court of Quo relied on the respondent's expert evidence to determine the meaning of the song Kill the Boer. However, in Masuku, the Constitutional Court held that it has long been held that an expert may not usurp the interpretive functions of our courts, and that the experts in this matter could not be used to determine the meaning of the statements. The court relied on the evidence of Mr. Malema to determine the meaning of the song, despite Kolani it being prohibited from doing so. Now, these discrepancies create the impression that the different rules were being applied by the court of Quo in a manner that is inconsistent with the rule of law. Litigants ought to be able to rely on the decisions of other courts when deciding how to conduct their own proceedings. In other words, the other cases must be guidance for litigants about how they will run their cases, what evidence will be used, what is important for determining context, what is important for determining the meaning of words. And if the rules are changed, then it changes the playing field. And there's a sense that some people are giving different sets of rules and different protections. Now, on the question of the listed grounds, Mr. Malema himself says, when I mention the word farmer, I see a white person. So when you say shoot to kill, kill the farmer, he's envisioning a person of a certain race being killed. Now, and I mentioned that the court in Masuku was able to see that the term Zionist clearly references Jews. In the matter of Hugo, Goldstone J. held that the prohibition on unfair discrimination in the interim constitution seeks not only to avoid discrimination against people who are members of disadvantaged groups, it seeks more than that. At the heart of the prohibition of unfair discrimination lies a recognition that the purpose of our new constitutional democratic order is the establishment of dignity and respect regardless of their membership in particular groups. The achievement of such a society in the context of our deeply inegalitarian past will not be easy, but that is the goal of the Constitution and should not be overlooked or forgotten. So the idea is that all citizens are provided protection by the law, that you cannot have Afrikaners being relegated to second-class citizens. You cannot have a double standard that is applied to them. There is a concern that the value of non-racialism is being undermined by a judgment like this. That if some races are given the impression that they will be silenced, while other races can say what they like about them, you destroy the very fabric of our modern democracy. The reason why South Africa has a promise of a future is the idea that it belongs to all who live in it, echoed by the words in the Freedom Charter. If some people are made to believe that they are second-class citizens, like they were during apartheid, that apartheid created different classes of citizens in a despicable way, that we will never go down that path again, it's important to embrace the idea of non-racialism. In Van Heerden, Moseneke held that the long-term goal of our society is a non-racial, non-sexist society, in which each person shall be recognized and treated as a human being of equal worth and dignity. In Walker, Justice Sachs held that no members of a racial group should be made to feel that they do not deserve equal concern, respect, and consideration, and that the law is likely to be used against them more harshly than others belonging to other racial groups. And in Khumalo, specifically in the context of hate speech, Justice Sutherland says the following. He says, in South Africa, our policy choice is that utterances that have the effect of inciting people to cause harm is intolerable because of the social damage it wreaks and the effect it has on impeding a drive towards non-racialism. The idea that in a given society, members of a subaltern group who disparage members of the ascendant group should be treated differently from the circumstances where the other way around has no place in the application of the Equality Act and would indeed subvert its very purpose. Our nation-building project recognizes a multitude of justifiable grievances derived from past oppression and racial domination. The value choice in the Constitution is that we must overcome the fissures among us. That cannot happen in debate if, however robust among ourselves, one section of the population is licensed to be condemnatory because its members were the victims of oppression, and the other section understood to be collectively the former oppressors are disciplined to remain silent.
Is there any further submissions? You've been reading out in your names, so we've read it already. So if there's nothing more.
Yes, there is one further statement to be made, which is that when looking at the clause designed by the court in Kolani, the phrase is as follows. It says, subject to the proviso in section 12, no person may publish, propagate, advocate, or communicate words that are based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention to be harmful or to incite harm and to promote or propagate hatred. Now, my learned friend Mr. Nkatobi described Lamont's approach in the original AfriForum case as being incorrect on the grounds that he said, well, there are two reasonable interpretations one could have about a song. And you could look at what the targeted group says and you could look at what others say. Now, and he says that's the wrong path to go and that it's not what the law requires. The fact that the new section 10 uses the word could reasonably implies that there could be multiple reasonable interpretations, and if any of them demonstrate the intention to incite hatred, then you are caught by the clause.
How does that relate to the premise of your addresses and amicus, which is about equality before the law?
Well, the idea is that...
You argue in the case that you argued for the peasants.
Justice, the implication is that the law must be applied evenly. That it's important that we have a standard that is applied to everyone, which means that when we're interpreting the words in any future hate speech case, it's important that this court sets out what that test is, that everybody knows in advance. Is it a reasonable interpretation, or is there only one reasonable interpretation? That is important for the rule of law, that any litigant knows in advance what standard they'll be held accountable to.
I thought they learned from Kolani.
Yes, so in other words, Kolani tells them, yes.
Thank you.
I have no further submissions.